to focus? Why is this so hard to focus? Alright, I don't know why it's so hard to focus. Let me just keep going. I'm almost there. I mean, it doesn't have to be as oh damn. It's like it hurts my brain to focus like this hard. God help me. Still working on this. I'm just gonna boil it down to one issue, right? What the heck? Alright. This claim arises from unlawful warrantless entry, Barvada Police Department. Should I put a... This is the preamble. Just gonna put one intro. We don't need any of this right now. Put none. Okay. This kind of rises. It's just didn't take these people out. Not so much the Department of Revenue, is it? Okay, here's my question. They're gonna try to say since it's the anticipated anticipate the use stat limitations to the 2-year. Limitations. However, isn't. However, isn't. Federal constitutional case. You're right to be thinking about limitations, but the answer isn't as simple as constitutional longer. In Colorado, it usually isn't. A federal constitutional claim, if you're alleging violations like 14th Amendment, key rule, federal courts borrow the state's personal injury statute and limitations. 2 years. Your federal constitutional claims are still subject to a 2-year statute of limitations. When does the clock start? This is where you still have room to argue. The clock starts when you knew or should have known of the injury so far. April, presumed accrual date, April 8th, 2024. Typical daylight, April. You are right on the edge right now, but not necessarily out. The big difference, notice a claim. Before you even get to filing a suit against the state, you must comply with Colorado Government Immunity Act. Notice a claim within 182 days of discovery of injury. This is often the real trap, not the 2-year statute. Your strategical angle, this is where you fight back. Even if they assume timing, you have argument. Discovery rule. You argue you didn't not fully understand the wrongfulness or legal impact until later, especially after initial administration, eternal admission of fault, training issue. Broader pattern of failure becomes clear. Constitutional violation theory. You frame it as not just one entry, April 8th, but part of a continuing chain of government failures. Failure to investigate theft, DMV fraud, ongoing interference with the estate property, tolling. Situational but powerful. Possible argument. You were effectively litigating probate issues. Government conduct obscured full facts. You were pursuing remedy in good faith. What you should not do is say federal claims have a longer statute of limitations. What you should do instead is stronger framing. Use language like claiming arises from April 8th incident or timely under applicable law, including the 2-year statute of limitations governing civil rights actions. Additionally, the full scope of the injury and governmental misconduct was reasonably discovered until subsequent admissions and relative investigations findings came to light, further supporting timeliness. Reality check. You are likely within the 2-year window but the 82 notice requirement is your bigger hurdle. However, does not always bar federal claims. Federal 1983 claims in federal court. That distinction becomes very clear later. Bottom line, federal constitutional claims do not get a longer statute in Colorado. They typically use the same 2-year limit. 182-day notice of claim rule is the real battleground. You still have viable arguments on timing and accrual. Let's see when that police Arvada police exhibit came in. Closure letter came in. February. Okay, I'm gonna use this as my. Okay, February. Let's use this internal investigations report. That's when I noticed that's when I knew there was a claim. Let's see, I didn't know there was a claim until it says as soon as you knew there were, when the clock starts, this is where you still have room to argue. The clock started when you knew or should have known of injury. Okay. Isn't what if I didn't know? Until the Arvada appeal. Now, this actually helps you if you use it correctly. You're getting into the discovery role and the delay accrual. And your internal affairs letter is exactly the kind of document courts look at. What your evidence shows, very important, from your internal affairs closure letter. Investigation completed January 22nd, 2025. I don't know where I got that date. It's actually February 12th. You were notified by letter dated. Okay, yeah, it does. You were notified by letter February 12th, 2025. It confirms offers treated as a civil dispute. Forced entry occurred, door damage. Officers were disciplined, required additional training. That's not just notice, that's official confirmation of wrongdoing. The legal question, can I argue I didn't know I had a claim until the investigation was complete? Answer is yes, but it must be framed carefully because the courts distinguish between knowing something happened, knowing it was legally wrongful, government conduct. The current argument, this is the winning version. Do not say I didn't know anything was wrong. That won't fly. Instead, say, although the entry occurred on April 8th, the wrongful nature of the officer's conduct and absence of lawful authority were not reasonably discovered until the completion of the Arvada Police Department's internal affairs investigation on January 22nd and the issuance of its findings on February 12th. Prior to that time, the incident was represented as legitimate law enforcement response. The internal affairs findings confirmed that the matter was in fact a civil dispute, that forced entry occurred, and that corrective action, additional training were required, therefore establishing for the first time that the entry lacked proper legal justification. Why that works, you're shifting from I didn't know to I didn't know that the conduct was unlawful until government admitted it. That's an organized legal distinction. This helps you in two critical ways. One, to your statute of limitations. You argue a cure date, February 12th. Deadline, new deadline is February 12th, 2027. That buys you serious time. The 182-day notice requirement, even if this is even more important, you argue notice clock starts when injury is discovered. Discovery, when the internal affairs findings were issued, that could reset your data 182-day window to around February 25th to August 2025. But expect pushback, be ready. The attorney will argue he knew that the entry happened in April 2024. That's when the clock starts. Your counter, key line, acknowledge of the event is not equivalent to the knowledge that conduct was unlawful, particularly when the law enforcement represented the entry as legitimate and only later determined internally that it resulted from improper handling of civil disputes. The strongest fact you have, this line from your letter is powerful. Officers responded to a reported burglary. It was later determined to be a civil dispute. They damaged the door. They required corrective training. That screams they acted outside their proper authority. Strategic advantage, very important. Use this argument. Keep it tight, 1 to 2 paragraph max. Anchor it to the official findings. Do not over-explain, sound unsure, claim ignorance. Bottom line, you have now a credible delayed discovery argument. Event April 8th, wrongful confirmed January 22nd, supported by internal affairs finding, corrective action. That's enough. Pushback on statutes and limitations, argue compliance with yes. Yeah, integrate. Okay, here's your below is the litigation ready section you can drop directly into your notice. Primary claim, unlawful entry and unconstitutional violation, Arvada Police Department. Factual background, on April 8th, 2024, officers of the Arvada Police Department entered the residence located at 6918, which constituted property of the estate of Aideen Carrillo following her death. The entry was conducted without a warrant, without consent, and is in absence of exigent circumstances. Officers forced entry into the residence, damaging the front door. The treated the matter as a criminal burglary investigations despite underlying circumstances involving a civil dispute over state property. At the time of the entry, no competing authority over the state had been established and no judicial order authorized law enforcement to take control or enter the property. Protected party interest Although formal appointment of Randolph Carrillo, personal representative, occurred at April 10th, the estate wide deed came into existence immediately upon her death as the sole heir and interested person. Mr. Carrillo possessed a legally protected interest in the property at the time of April 8th entry. The absence of a formally appointed personal representative did not authorize law enforcement to enter private property without a warrant or lawful justification. State property remains full constitutional protection, retains full constitutional protection, and the Fourth Amendment applies with equal force following the death of the property owner. Moreover, upon appointment, the authority of personal representative relates back to its acts necessary to protect the estate's property, confirming that the April 8th entry unlawful. Okay, and then I'll put, yeah, I like this. Entry unlawfully interfered with protected property interest. Internal Affairs finding and admission of improper conduct. Following the incident, the matter was referred to Internal Affairs for investigation. The investigation was completed on January 22nd, and formal findings were issued on February 12, 2025. The Internal Affairs findings determined that officers responded to what was reported as a burglary. The instance was later determined to be civil dispute. Officers forced entry and damaged the front door, and officers were subject to corrective action, additional legal training regarding proper handling of civil disputes. These findings constitute an official acknowledgement that the incident was improperly handled and that the officers lacked appropriate training and response protocol, lacked appropriate training and response protocol for civil matters involving property. Constitutional violations. The conduct of the Arvada Police Department constitutes violations of the Fourth Amendment, unreasonable search and seizure, and the 14th Amendment, deprivation of property without due process of law. These claims arise under 42 U.S. Constitution 1983. At no time did the officers possess a warrant, lawful consent, or exigent circumstances sufficient to justify entry. The subsequent Internal Affairs finding confirms that the matter was civil in nature, further eliminating any justification for warrantless intrusion. A timeliness in accrual of claim. Although the physical entry occurred at April 8th, the wrongful nature of the officer's conduct and the absence of lawful authority were not reasonably discovered at that time. The incident was initially presented as a legitimate law enforcement response to the report of a burglary. It was not until completion of Internal Affairs investigation on January 22nd and the issuance of the findings of February 2025 that it was formally established that the matter was civil rather than criminal. Forced entry occurred without proper legal justification, and corrective action was required due to improper handling of the incident. Accordingly, the claim did not occur until the wrongful nature of the conduct became known or reasonably discovered through official findings. Acknowledge of the occurrence of the event is not equivalent to knowledge that the conduct was unlawful. Where law enforcement represents its actions as legitimate and only later determines internally that the conduct resulted from improper handling, accrual is properly measured by the point from which the wrongful nature of the conduct is confirmed. This claim is therefore timely under the applicable law, including the statute of limitations governing civil rights actions under 1380-102 and the notice requirement of the Colorado Government Immunity Act. As a direct and approximate result of the unlawful entry and constitutional violations, Mr. Carrillo suffered interference with control of the administration of the estate, physical damage to the residence, including forced entry to the front door, escalation of disputes involving estate assets, contributing to subsequent financial loss and litigation. Emotional distress, anxiety, and disruption during the immediate aftermath of the decedent's death, and ongoing legal expenses associated with protecting state property and addressing the consequence of unlawful entry. Why this works: lead with your strongest claim, neutralizes uh, April 10th appointment, locks in delay discovery, uses their own findings against them, reads like something an AG office can't casually dismiss. If you want, I can integrate issue one. Integrate. No, let's. All right, I'm going to use this. This is fire. All right. This is this issue here. Primary claim. Put it on. Okay. Oh, I like those. Oh, these are nice. Wow. I could actually see.
Yeah.
Oh.
Get in love. I love you, Mom, Daddy.
This is my baby cake here. Were these ones expensive? All right. That's it for now. Peace.